All right, who did you want to call first?
I believe if we could start with the Travis Arnett brain cases.
I have docket 25-01476 and 25-02006. And then 25-02006. Will the parties please introduce themselves to the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the People.
Mr. Koontz.
Good morning, Your Honor. Dustin Koontz for Travis Arnett Brain on both cases, although my physical appearance is not yet in the new file.
All right, and sir, you are Travis Arnett Brain, is that correct?
Yes, sir.
All right, thank you. This is the time set for a contempt hearing on, I have a contempt hearing on 25-01476, and then I have a PCC on the same file and 25-02006. Is that what you have, Ms. Ezell?
It is, Your Honor.
All right, how are we proceeding today?
Your Honor, at this time, we're going to be asking for all of these to be adjourned because there is a new case that's coming through the system for Mr. Arnett Brain. That case is set for a PCC, I believe, on August 7th. We would be asking the court to move all of these cases to that same day.
All right, and is that a fair statement, Mr. Koontz?
I don't, not quite, from my understanding. I think on the new case, the prelim is currently set for next week. The August 7th date that Mrs. L and I were talking about is a date I'll be here on another prelim for an unrelated case. Asking that both of these cases be set for prelim that same day if the court still has availability on August 7th. That would require a 21-day waiver in the new case.
Right.
And then as far as the contempt hearing, the basis for that is the factual basis for the new case. Allegations of pleading and eluding.
Right.
So I think we both agree it makes sense to handle it all.
Handle everything together. All right, first of all, let's check the date of August 7th.
I'm trying to find his new case because it's not scheduled on any of the dates that the parties just indicated it was scheduled for.
So the new case is scheduled for next week, right?
I have it on my calendar as the prelim is set for July 24th.
Okay.
So that case would also be moving to August 7th.
That's right.
Okay. So do you want to do that now and we can handle all three cases together?
I think that would work.
Case of his that is set for July 24th is the case that we just called on the 2006. Because I'm not understanding something. The case for 25-02006 is scheduled for prelim on July 24th. I don't see a third case.
I think that's correct then. I'm not seeing a third case in my system either. I do think I misspoke.
All
I
right.
apologize.
So the 25-02006 case is the new case.
Yes.
Okay. And that's the case that would be adjourning both of these files to August 7th.
Yes, Your Honor.
For prelim, not another
For prelims. Okay. So you are right.
Okay,
You are right.
I'm just trying to make sure like I don't mess up.
So we have the two cases. So we'd only require a waiver on the 21-day rule on the 25-02006 case, and then we'd move them both to August 7th.
I can do August 7th at 9:30.
Okay, August 7th at 9:30. And that works for your schedule, Mr. Koontz, the August 7th at 9:30 date.
Yes, Your Honor. I'm already going to be here.
All right, and so may I inquire of Mr. Arnett Brain has waived his 21-day rule on 25-01476. May I inquire of Mr. Arnett of his waiver of the 21-day rule on 2502-006?
Of course, Your Honor.
All right. Mr. Arnett Brain, you understand you have a right to a preliminary examination. I think this is set for July 24th. Yeah, prelim is set for July 24th. You have a right to a prelim within the 21 days period of your date of arraignment. You would not be waiving a prelim in general. You would just be waiving your right to a prelim within that 21-day period. The preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. It's my understanding would be your wish today to waive your right to a prelim within that 21-day period, have this reset with August 7th to August 7th for the court to handle both files at the same time. Is it your wish to waive your right to preliminary examination on 2502-006 to August 7th at 9:30?
Yes, sir.
The people also waive the right to a prelim outside the 21-day period.
We do, Your Honor.
All right. I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made, and will reset for August 7th at 9:30 for file 2501-476 and 2502-006. And then we'll also reset the bond violation hearing for that same date. Is that true? Is that a fair statement, Mrs. Zell?
It is, Your Honor.
And is that a fair statement, Mr. Coons?
Yes, Your Honor.
All right. Anything else for the record in 2502-006 and 2501-476? We've adjourned both matters to August 7th at 9:30. Mrs. Zell.
Not for the people.
Mr. Coons.
Nothing else. Thank you.
All right, Mr. Arnett Brain, you're all set. Thank you for your briefs.
Thank you.
I believe we're ready on Mr. John White's case.
You're gonna see, you can, here, sit down here for a second.
How are you, Jody?
Right there. I think she went to chase down somebody who notices.
All right. Perfect. All right, so we're on the record in docket 25-01165. That is people of the state of Michigan versus John Gilbert Charles James White Jr. Will the parties please introduce themselves to the record? Mrs. Zell.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Ms. Thompson.
Assistant Public Defender Sarah Donnelly on behalf of the defendant John White, who is to my right.
And sir, you are John White Jr., is that correct?
Yes, sir.
All right, thank you. This is the time set for a sentencing on the matter. Ms. Zell, do you know of any restitution in this matter?
Do not believe there is restitution in this matter.
All
Your
right,
Honor.
thank you. Ms. Donnelly, have you had the opportunity to go through the pre-sentence report with your client?
I have, Your Honor.
Any additions, deletions, or corrections?
No, Your Honor.
Allocution, Ms. Donnelly.
Thank you, Your Honor. Mr. White obviously has pled guilty to assault and battery here. He is not trying to run away from his accountability. He wants, he appreciates the court consideration in this, especially with the recommendation of probation. In regards to the recommendations, though, one concern that he does have is that he reports he doesn't use drugs or alcohol. And he's concerned that he can't afford the drug testing. I told him that obviously it's not determined today how much he has to drug test, if anything.
Right.
But I told him that I would bring those up to the judge because obviously that's a very good valid concern. You know, the drug tests at AverHealth are at least $20 a test. So depending upon how much he has to test, you know, it could be if he has to test once a week, that's, you know, $80, a month. So something like that, you know, it's just is a cause for concern. I don't want him to, you know, I want to be successful at probation. I feel like I agree that he's a good candidate for probation. Certainly he can get like mental health counseling, anger management. He can get those things for free through community mental health in a lot of ways. So I believe that, you know, he does have what he needs to be successful. It's just, that was his major concern. But other than that, Your Honor, we don't have any other objections to the recommendations. Again, I believe that Mr. White is a very good candidate for probation. I've talked to him about early termination and other also if it was all possible because of his financial status. I know that sometimes the court will waive the probation oversight fees. I don't know if it's possible anymore, but if the court would consider that, I think that's it, Your Honor. Thank you.
All right. Is there any indication of, I can't find any indication that drugs or alcohol were used during the incident. So I just want to make sure that we're talking about the incident of April 18th. I don't find any drugs or alcohol mentioned in that police report. Would that be a fair statement, Ms. Conley?
Yes, Your Honor.
All right, Mrs. L, do you have any questions or anything comment concerning Mr. White's sentencing?
Before that, Your Honor, one thing I forgot. Thank you. One of the conditions is that he needs to obtain or maintain employment. Mr. White is currently on disability, and obviously he has mobility issues. He uses a wheelchair. So I would just ask the court consider not setting that as a condition of probation. That's it. Thank you.
Thank you. Mrs. L.
Thank you, Your Honor. Just briefly, we would like to just state that when originally charged, Mr. White was charged as a habitual fourth. We think this is important to bring to the court's attention, as that criminal history is very assaultive in base. Additionally, Your Honor, if I could just read a brief statement, the impact statement from the victim.
Absolutely.
He states, "The way he made me feel was hopeless and scared. I did not know whether he was going to stab me or kill me. I am afraid that he could come back and hurt me at any time, or I see him in the streets. I also have had nightmares about the incident since this happened, and sometimes I wake up and I'm scared from those nightmares." Your Honor, we would ask that you take this into account, the way that this has impacted the victim in the sentencing today. Thank you.
I am correct in noticing the habitual offender indication here. I don't see anything after 2007. Is that a fair statement?
It is, Your Honor.
Okay. All right, Mr. White, is there anything you'd like to say to the court before the court passes sentence?
Yes, sir. I appreciate anything that you're going to give me, and you know you know that I'm disabled and everything, so I appreciate anything you can have mercy on me and stuff. Well, I don't have no problem with probation. I don't have no problem with probation. I said Sylvester did my parole 2017, 2018. And I had no trouble. I never got dirty. I never blew up dirty. Oh, I haven't drank for like, yes, in 2007, 2013. And I kept going back to prison for drinking. But after 2013, I was from 2013, 2017. You know, that long in prison just had an impact on me. So I stopped drinking, and I ain't done drugs for a really long time. I don't like the way they made me feel, the way they made me feel at the time and stuff. So I don't do drugs, I don't do alcohol, I can complete this probation stuff if you can let me do it.
All right, this is for a guilty plea on assault and battery out of May 16th, 2025. This is a no contest plea. There's a sentence of the court that the defendant spend 93 days in jail, credits given for 2 days previously served. I'll suspend 91 days upon successful completion of probation. We'll have a fine of $100, cost of $100, crime victims' rights fee of $75, state minimum cost fee of $50, and then probation is set at $30 a month for 10 months. So I'll give you all of that will be due at the end of probation. I'll give you a grand total for that. That's,
Over 10 months probation, Your Honor.
yeah, I'm the 10 months probation would be 300 plus 125 plus 200. I have 625. So I am following the recommendation of the JOS. In regards to some of this, there's going to be two minor changes to this. Most of it's based on some of your criminal history and some of the fact of what you've said today. Okay. So no assaultive or threatening behavior, no use of possession of alcohol, marijuana, or controlled substance without a prescription. I'm going to strike submit to random PBTs in your analysis as directed. So this doesn't strike the portion of you can't use alcohol, marijuana, or controlled substance because you've indicated you're not. This will strike the testing portion, which may be a financial burden. Okay. No bars or nightclubs. I think that's a good idea. Complete following rehabilitative services, pay fees, and provide proof of completion to the court. You should finish the anger management group and then provide any mental health counseling that's ongoing. I'm going to strike the obtain, maintain employment since it's obvious that if Mr. White's on disability, and then not purchase or possess firearms, ammunitions, or weapons of any kind. Your probation agent is going to be Brendan Hanna. He's a pretty easy guy to work with, pretty flexible. So make sure you go to the 5th floor and understand how he wants to meet via Zoom, anything like that. But he's all the probation, as I see it, are pretty easy to work with. Anything towards the judgment of sentence, Ms. Donlin?
No, Your Honor.
Mr. White, do you have any questions of me concerning the judgment of sentence?
Well, my point is,
What was the total? Did you give it?
The total is 625. I have 625, but that can't be right.
Well, you said $100 for a fine.
So it's 200 for fines and costs, plus 75 crime victims' rights fee, plus 50 state fee, plus
325 plus 10 months probation is $300. So
$625.
yeah, that's 625. Yeah.
yeah.
But
So my math was right. So yeah, I will order the $30 per month probation at this point in time, and anything concerning you're not ordered to submit to random PBTs, enter your analysis, and then the disability obviously is not a part of this order. Anything towards the judgment of sentence, Mr. White?
no.
Okay, thank you. All right. I think this will be able to read, so we don't have to print this out. Unless there's a read, but I think the rights. All right, Mr. White, you're all set. Thank you for your appearance today.
Thank you, sir.
I'll walk you down to probation.
Thank you.
All right, Mrs. Zell, where are we heading next?
That was a great question.
Did you want to meet with some? You know, we've got Mr. Johnson's here.
We do Kelsinski. I'm here for Mr. Freeman.
Let's do it.
Sorry, because I've got
sentencing over.
Absolutely.
Judge Simmons.
That is Kalzinski.
Yes, sir.
Corey Kalzinski. All right. All right, so we're on the record in docket 25-01615. That is People of the State of Michigan versus Corey Kalzinski. Will the parties please introduce themselves for the record? Mrs. L.
Your Honor, Gabrielle Ezel, Assistant Prosecutor for the people.
Mr. Mills.
Good morning, Your Honor. Stephen Milks from the County Public Defender's Office, representing Mr. Kelzinski. I am standing in for Attorney of Record Steve Freeman. I believe Mr. Kelzinski is over Zoom. That's
And sir, you are Corey Kalzinski, and you'll have to unmute. Right, sir, we still have you on mute.
Your Honor, earlier he did indicate he was having a little bit of trouble with his phone.
All right, and Mr. Milks, you've indicated that is Corey Kalzinski, is that correct?
I believe so, Your Honor.
There we go. And sir, you are Corey Kalzinski, is that correct?
Yes, Your Honor.
And you can hear me all right, Mr. Kalzinski?
Kind of, yes, kind of, yeah.
All right. All right, thank you. This is the time set for a probable cause conference. Mrs. L, how are we proceeding?
Your Honor, it's my understanding we're going to be leaving this set for a preliminary exam.
Is that a fair statement, Mr. Mills?
That is a fair statement, Your Honor. I believe my client has already waived 21 days. I think this has been adjourned at least a few times.
All right. Yeah, we previously waived the 21-day rule on June 13th. It's set for July 24th. Is that correct?
Yes, Your Honor, I believe so.
It is.
All right, so we'll leave on for prelim on July 24th at 9 o'clock. So that'll be live in person on the 6th floor of City Hall. Mr. Kalzinski, that'll be next Thursday at 9 o'clock. Anything else for the record in 25-01615, Mrs. L?
Not the people.
Mr. Milks.
Just very quickly, Your Honor, and I'm completely surprising Mrs. L with this one. Part of the search here was based on a probation order. We just don't have that in discovery yet. I don't think we even requested it. So I guess I'm just going to hope that we can get that in, and I'll send an email to Mrs. L because again, I've surprised her completely with this one.
All right. So there is an outstanding, or defense would like to see the probation order concerning Mr. Kalzinski, who was, I'm assuming the order. Do you want to see the order that's signed by him, or the actual? Because he signs an order for probation.
Yeah, just the conditions that are laid out, Your Honor.
All right. With that understanding, Mr. Kalzinski, we'll see you at 9 o'clock next Thursday. And that's all for the record in 25-01615. You're all set, sir. Okay.
All right, thank you.
Thank you.
Thank you, Your Honor.
We're all set.
Sounds good.
Appreciate it.
We'll see you, Mr. Milks.
I'll be here again, Your Honor.
Okay.
During that quickly.
I don't understand why this is set for July. I think
It's set for next week.
Yeah.
let's go back to June.
That's what I'm doing. I'm going to ask for.
Apparently the sentencing is in the works of being adjourned by stipulation that Mr. Martinez and Mr. White are
All right.
apparently working out.
It's Adonis.
Thomas Adonis.
So if you
Well, hold on to the file. I'll have to stipulate shortly. Or if you want to give it to me, so it's not your desk, that's fine too.
I'll just put it.
That'll be a good one. Okay. I think we're ready on Dickey's mask.
Snaps. All right, so we're on the record in docket 25-02009. That is, I'm sorry, 25-01620. That is people of the state of Michigan versus DeKeese Mask. Will the parties please introduce themselves for the record? Mrs. Zell.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Lee.
Thank you, Your Honor. Assistant Public Defender John Lee on behalf of DeQuise Devon Mask.
And sir, you are DeQuise Devon Mask, is that correct?
DeQuise.
Thank you. This is the time set for a probable cause conference. Mrs. Zell, how are we proceeding?
Your Honor, it's my understanding that we're going to be asking for another probable cause conference to be set. I am going to defer to Mr. Lee to make a record.
Okay, Mr. Lee.
Thank you, Your Honor. Mr. Mask has been consulting with an attorney that his family has a relationship with. He has paid that attorney a substantial down payment on the total that the attorney wants for the case. However, at this time, they do not have an official retainer agreement, and there is more money owed. Mr. Mask is working full-time. His brother is assisting him. They are in the process of raising the money and retaining the attorney, but at this point has been unable to execute.
All right, so at this time, the request is adjournment in order to get sufficient funds to make sure that the attorney's retainer, the attorney last time that you spoke was Dwayne Boyd, is that correct?
Yes, sir.
Mr. Lee, is Mr. Mask prepared to waive his rule, his 21-day rule? So this would be outside of the 21-day period because this would be the third good cause adjournment.
Yes, sir.
All right. Any objection to the request for adjournment if the defendant waives their preliminary examination within 21 days?
No objection.
All right. All right. May I inquire of your client of his waiver of the 21-day?
Yes, Your Honor.
Okay. All right, Mr. Mask, you understand you have a right to a preliminary examination within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by attorney John Lee, who'd be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding that on June 13th and July 3rd, we adjourned this so that your family could retain counsel. And that's in the works, that's in the process. But those were both good cause adjournments. Now we're looking to adjourn this once again. In order to do that, you'd waive your right to a prelim within 21 days. You wouldn't be waiving your right to a prelim in general, just within that 21-day period, so we can reset it so your family can set this process with attorney Mr. Boyd. Is it your wish today to waive your right to a preliminary examination within the 21-day period? And Mrs. Elder, the people also waive their right to a prelim within 21 days.
We do, Your Honor.
Yeah, I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made. We don't know Mr. Boyd's schedule, so we'll just set it for PCC and then wait to hear if that works with the schedule. And you'd need at least 2 to 3 weeks for subpoenas, I would imagine. Well, for PCC, it doesn't matter.
Correct, Your Honor.
Okay, so reset for PCC. Let's go 3 weeks and then make sure you give this date to Mr. Boyd so he knows.
Friday,
Okay, Friday, August
August 18th.
8th, 8:30. And what waiving of the 21-day rule today, what this will give you is if Mr. Boyd has a conflict for that date, it's kind of built in that we can reset it without everybody coming back to court for the PCC, which is the fear. The fear is we don't know Mr. Boyd's schedule. We're going to set it. There's going to be a conflict, and then we have to reset it. We can do that now that you waive the 21-day rule. Anything else for the record in 25-01620? It's been set for Friday, August 8th at 8:30. Mrs. Zell.
Not the people.
Mr. Lee.
No, thank you, Your Honor.
All right, Mr. Mask, you're all set. Thank you for your.
Thank you, sir.
And I believe we are ready on Darnell Wheaton, Your Honor.
you to see that good, I took these off, Your Honor, because of they being like sunglasses.
All right. All right, so we're on the record in 25-01656. That is people of the state of Michigan versus Darnell Wheaton. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the People.
Ms. Wanji.
Good morning, Your Honor. Melanie L.B. for Mr. Darnell Whitten, who is at the council table.
And sir, you are Darnell Wheaton, is that correct?
Yes, sir.
Right, thank you. This is the time set for preliminary examination today. Mrs. L, how we proceed?
Your Honor, it's my understanding that Mr. Wheaton is undergoing screening for mental health court, and that screening is still happening. We are asking for an additional adjournment to complete that process.
And is that a fair statement, Ms. Wanji?
Yes, Your Honor. My client has already started part of the screening for the treatment fork, and now we're just waiting for the CMH part.
Okay. And the waiver of the 21-day rule was done on June 20th. So let's reset this. Do you want this reset for prelim or PCC, Mrs. L? It doesn't matter because we're in the same boat.
I think if we set it for PCC, I think that should be fine.
All right.
That's fine, Your Honor.
All right. We'll reset for PCC. I know it takes some time to be screened from the mental health court. So that might build in some time. About what's our time frame? That's the hard part,
At
really.
least 30 more days.
Started the process on 6/20 according to last hearing.
That's correct.
So I would say 30 days, maybe. So around that time period of just to make sure that the screening's ongoing and the process is ongoing. I don't know what's available.
So we're just gonna do a PCC.
Yeah, PCC in about a month's time.
August 15th at 8:30.
August 15th.
I will
Yeah.
have someone call back on.
Okay. August 15th at 8:30 for PCC. And then that may just be a formality to move this to, because I think they have got their own rules in specialty court.
Yeah, they all think.
They'll take, yeah. All right, anything else for the record in 25? We've adjourned this to August 15th at 8:30. Anything else for the record in 25-01656, Mrs. L?
Not for the people.
Ms. Wanji?
Nothing for the defense.
All right, Mr. Wheaton, we'll see you on August 15th at 8:30. We're just building in time to let the process continue so you can get to the specialty court, okay? All right, that's all for the record on 25-01656. Thank you, everybody, for your appearance.
All right, good one. You're welcome. All right, that's all for today.
Ms. Earl, have you, you can unmute. Triana Earl,
Yes,
have you made application to the Public Defender's Office?
yes, I did, and I had got denied. but I don't know why I got denied because I told.
All right, stand by. You're in the right place. We'll call your case in a second. All right, so Lance Gailey, let's call your case.
Yes, sir.
All right. So we're on the record in docket 25-02061. That is people of the state of Michigan versus Lance Gailey. This is set for a probable cause conference. Mrs. Zell, your appearance.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Ms. Schroeder.
Thank you, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Gailey, who joins us from the Ingham County Jail.
And sir, you are Lance Gailey, is that correct?
Yes, sir.
All right, thank you. This is the time set for a probable cause conference. I have an order of competency in the file. Mrs. Zell, how are we proceeding? I believe a packet has been done.
Correct, Your Honor. At this time, I do believe we are going to be asking for an adjournment for that forensic review to be completed.
All right, is that a fair statement, Ms. Schroeder?
It is, Your Honor. I feel that it is necessary due to Mr. Gailey's medical concerns. It's essential to his due process rights. Thank you.
All right, thank you. I'm going to sign the order for competency review. So that would be the evaluation. 7/17/2025. And we'll adjourn this matter. Adjourn. Subject to competency review. The order's been signed. And I'm assuming that they will set up an interview with Mr. Gailey. Is that a fair statement, Mrs. Zell?
I believe so, Your Honor.
Ms. Schroeder.
I believe so, Your Honor. I would ask that the court consider the bond at this time. My understanding is Mr. Gailey's not getting the kind of medical treatment he's supposed to get in the jail. He does have grand mal seizures, and he's had several seizures since he's been in there. One is recently, I think is 3 days ago, if I'm correct.
All right, so the formal request for reduced bond in this matter, and I'll let you make a record, Ms. Schroeder.
Yes, Your Honor. I would ask the court to consider a PR bond. He does have somewhere to go. He has an uncle he's been staying with, somebody he has been also helping to care for, who is terminally ill, is my understanding, his uncle. That is the address that, of course, I don't have it in front of me, but I believe it is the address we have on file of both the court and our office. And as far as I know, he has not failed to appear on this file at all, and he has not been able to make bond, even though for lack of a better way to put it, it is 10% of $1,000. It's $100, but he has no means. Thank you. And he has medical issues that are going on.
All right, Mrs. Zell.
Thank you, Your Honor. We would ask that the bond remain at the amount it is at. This is a home invasion case, Your Honor, and speaking with the complaining witnesses in this case, they were pretty terrified and shaken up after this incident. If Your Honor is inclined to give that PR bond, we would be requesting GPS tether and potentially notification for those victims of that home invasion. Thank you.
Right, until the review's done, I'm not inclined to modify bond on this matter for $1,000, 10%, which was set by Magistrate Kelly, I believe. I will order that there's a full review of the medical status and meds in this matter, so that if there is not getting treatment, which Mr. Gailey so desperately needs, that should be reviewed and then followed.
Thank you. Do we have, I'm sorry, I may have missed it if we got a review date for.
Let's, I think that's an excellent idea. Let's set it for a control date to see where we are in regards to, so the control date. And should we set it 30 days out?
I think. Can we split the baby and say 60?
60.
Because then at least we know.
Let's do 60 days out. Just to make sure the review, the evaluation being done, because that's where we run into problems, is getting the evaluation done and then we're waiting for a report.
Yes.
And that's when that's where the problems exist. And so I don't think we have a problem. One of these is a 93-day misdemeanor. So that would be problematic in that regard. All right, so we'll set it for 60 days out, control date. And that would be in that vicinity.
I'm so sorry. October 3rd at 8:30.
All right, we'll set a control date for October 3rd at 8:30, just so it doesn't fall through the cracks. I've signed the order of competency, and then we'll wait for the evaluation to be done and the report to follow. Anything else for the record in 25-02061, Mrs. Zell?
Not for the people.
Ms. Schroeder?
Not the defense, thank you.
You're all set, Mr. Gailey. There should be somebody out to see you, hopefully, within the next 2 weeks, if not 30 days. You're all set, sir.
Thank you.
Thank you, sir. All right, Mr. Howell, we're ready to call your case.
All right, Your Honor, thank you.
So we're on the record in docket 22-03340. That is people of the state of Michigan versus Tyrone Howell. Will the parties please introduce themselves for the record? Mrs. Zell.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Ms. Schroeder.
And Assistant Public Defender Aaron Schroeder on behalf of Mr. Howell, who joins us from the Ingham County Jail.
And sir, you are Tyrone Howell, is that correct? And you can hear me all right, Mr. Howell?
Yes, Your Honor.
All right, thank you. This is time set for a probable cause conference. Mrs. L, how are we proceeding?
Your Honor, it's my understanding we're going to be leaving this set for the preliminary exam.
Is that a fair statement, Ms. Schroeder?
It is, Your Honor, and we will be prepared to run it at that time. Thank you.
All right, so we've set it, it'll be left on for July 24th at 8:30. All right, so that's a week from today at 8:30. We'll leave on for preliminary examination. Anything else for the record in docket 22-03340, Mrs. L?
Not for the people.
Ms. Schroeder.
Not for the defense.
All right, Ms. Howell, Mr. Howell, we'll see you next week at 8:30. Thank you for your appearance today.
No problem. Thank you, Your Honor. Oh.
All right, Kelvin Hunt, you can unmute. All right, and we're going to call your case next, sir. So we're on the record in docket 25-02009. That is people of the state of Michigan versus Kelvin Hunt. Will the parties please introduce themselves to the record? Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Ms. Schroeder.
Thank you, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Hunt, who joins us via Zoom.
And sir, you are Kelvin Lamar Hunt, is that correct?
Yes, Your Honor.
All right, and you can hear me all right, Mr. Hunt?
Yeah.
Thank you. This is a time set for a probable cause conference. Mrs. L, how are we proceeding?
Your Honor, it's my understanding that we're going to be leaving this set for the preliminary exam.
And is that a fair statement, Ms. Schroeder?
It is, Your Honor. Thank you, and we will be ready.
So we'll leave on for the scheduled preliminary examination for July 24th at 8:30. That'll be live in person on the 6th floor of City Hall of Lansing. And that'll be next Thursday at 8:30. Anything else for the record in 25-02009, Mrs. L?
Not for the people.
Ms. Schroeder.
Now for the defense.
All right, Mr. Hunt, we will see you next week at 8:30 live in person on the 6th floor of City Hall of Lansing. All right, sir?
Yes, Your Honor.
All right, that's all for the record in 25-02009.
All right.
Thank you, Your Honor.
Thank you, Ms. Schroeder. So you should be all set, Mr. Hunt.
All right. Thank you.
Thank you.
All right, Miss Earl, we'll call your case. You can unmute.
Yes.
All right. So we're on the record in 25-01921. That is People of the State of Michigan versus Treyana Earl. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the People.
And ma'am, you are Treyana Earl, is that correct?
Yes, I am.
All right, you can hear me all right, Miss Earl?
Yes, can you hear me?
I can, thank you. This is time set for a probable cause conference. And Miss Earl, at this time, you are not represented by counsel, is that correct?
Mm.
Is that a yes or no, ma'am? I couldn't hear you.
No.
All right. And you've made application to the public defender's office and you indicated you were denied?
Yes.
All right. Mrs. L, I'd say we leave this on for prelim.
I think that would work.
All right. So Miss Earl, we're going to leave this on for prelim. This is a probable cause conference for negotiations to happen before prelim, but we're going to leave this on for prelim for July 24th at 8:30. So Miss Earl, that'll be live in person on the 6th floor of City Hall of Lansing. You should be here live, and then you may want to go back to the public defender's office to make to see if you can appeal their decision, because you should have a lawyer next week for this felony preliminary examination. I believe this is set for retail fraud in the first degree. So it's punishable by up to 5 years. So you should have some attorney here to look out for your interests. All right, ma'am?
Okay.
All right. So you'll be live in person on July 24th at 8:30. That's live on the 6th floor City Hall of Lansing. Anything else for the record in 25-01921, Mrs. L?
Not with People.
Miss Earl, do you have any questions of me?
No, I do not. Thank you.
All right. We'll see you next week at this time at 8:30. Thank you.
Well.
Ms. Woods, would you like to say anything on behalf of yourself or the people concerning this matter? You can unmute.
Good morning. Yes, I would. As a mom, I just.
All right, before you get started, you are Sakara Woods, and that's SAKERAWOODS. Is that correct, ma'am? All right, you may proceed.
As a mom, it just is really unsettling that someone that is very unpredictable and has no regard to anyone's children, including her own, is walking freely. Like, you ran into a house that you know my children stay in. You beat on windows and doors knowing that my children stay in that household. By the luck of the draw, we just so happened to have our children next door, but that didn't stop anything. We've heard, the kids heard everything happening. So, the following Monday after the event took place, like, my children, before they got out of like the car to get into the school building, asked me if she was going to come up to their school and cause issues. Like, as a mom, that's very concerning because, again, like I said, you have your own kids and you didn't take any regard into your own children, my children. And that's just, again, unsettling to know that someone unpredictable will do things like that while under the influence and regularly, because popping up at a house wasn't the first time. She came 3 times that night, and 2 weeks prior she did the same thing. It's just been constant issues. I've had to deal with constant harassment from her since the beginning of the year up until current. And even still, after everything that has taken place, myself nor Shay Anthony feel like she's taken this entire thing seriously. She's still poking fun about the situation online. She has entered her exclusion zones a couple of times because I've gotten those text messages. It's just, it's insane to me that someone doesn't understand the severity of their actions when, again, as stated, they're also a mother and didn't take in regard their own children, let alone someone else's.
All right. Thank you, Ms. Woods. And you also indicated the same in a letter involving this matter, some of the same allegations. I don't see a date on that letter. So do you want to place a date on the letter you wrote concerning this case? When did you write that letter?
Your Honor, I'm sorry. I'm not in receipt of a letter. Was there a letter sent?
Yeah, I have a letter in the file.
If the court's
it's in the
considering-
probation, so if you have a date on it, I'll put the date on it, and then we can release it to both parties.
Yes, Your Honor, it was my understanding that probation, when speaking to Ms. did tell her that the letter would be sent directly to the court and not shared with the parties.
All right.
She specifically sent it only to the court for that specific reason.
But the only reason I make mention of it is to get a date on it because I don't have a date. I'm pretty much following the judgment of sentence as requested, but I don't have a date on the letter.
Because if it is something that the court is taking into consideration, I think that we're at least entitled to have it or at least review that, Your Honor.
I'm not only. I think it's been indicated in that there's some question concerning the no contact order that's been resolved, and I think you've argued that.
Okay.
That's the majority that I see of the letter.
Okay. I would at least like to address at least some of these accusations. Sure. But I'm sorry. Thank you for noting my concern here.
No worries. Ms. Wood, do you have a date that you want to put on this letter?
I wrote the letter on June 27th, and that's the day that I sent it over to probation as well.
All right. So what date is that again, ma'am?
June 27th.
Okay. All right. Anything else you'd like to say to the court, Ms. Woods?
No, not at this time, Your Honor.
All right. Response, Mr. Milks.
Thank you very much, Your Honor. Your Honor, this is just in regard to this brand new allegation of repeated and constant violations here, Your Honor. If the court is taking that into consideration in any respect, I would implore this court to allow us the opportunity for calling Mr. Naves, someone I have tremendous respect for, his investigations regarding probation oversight. There has been one concern that has been brought to at least his attention regarding GPS tether, which was a minor exclusion zone infraction. My understanding is it was in and out, something where she just crossed the border while traveling. There's not been this consistent, pervasive violation of the bond conditions. And I take complete umbrage with the fact that the victim's getting up here and saying this sort of thing when we would have evidence of that, Your Honor. If there were these ongoing persistence, this court would drag a client in so fast and with the penalty of or threat of jail, Your Honor. And that is just not the case here. My client is adamant that she's not had any communications online with Ms. Woods. And again, if these are things that are going to be taken into consideration, I think we should be entitled at least to some sort of hearing at this point.
I think all I'm taking into consideration are on somewhat any confirmation that actually confirms the pre-sentence report done by Mr. Ness.
Okay, thank you, sir.
Anything else, Mrs. L, concerning the judgment of sentencing?
No, Your Honor.
All right. So this is for a guilty plea on May 22nd, 2025. It's an entry without permission and a domestic violence complaint. I think I've heard enough that Mr. Neves is trying to walk the line. This sounds like a...
Your Honor, I'm incredibly sorry.
Sure.
I've been taking up way too much time, but I don't think my client had the opportunity to speak.
You're right.
And I
apologize. You're absolutely right. Ms. Woods, I'm sorry. Ms. Noguera, is there anything you'd like to say to the court before the court passes sentence?
Yes, sir. I just wanted to say to the court that I do take accountability for any actions that I did do when I did do this offense. I am a single mother and I did not have my children that night, and I am terribly sorry. I know I made a mistake and I'm trying to learn from it and move on from it and do the probation that I need to do and your management that I need to do. And I don't want to be back into this court for any other offense at all, ever. Anything that's going to take away from my kids, I've learned my mistakes. And like I said, I'm just trying to move on from it.
All right. Thank you. Thank you, Mr. Mills.
Thank you. No, I'm
completely
sorry.
passed over this statement from the defendant, probably the most important statement. So this involves the guilty plea on May 22nd, 2025 of an entry without permission and domestic violence. I've read the pre-sentence report. I've had the opportunity to listen to the victim's statement. And so this is fairly straightforward, but I am going to place you on probation, okay? Probation for 10 months, and we're going to talk about that. Part of the probation is no contact with Ms. Woods. And so any allegation of contact, you're just going to end up in front of me today. And as Mr. Milks has indicated, I take it very seriously. So I'm not concerned about Michaela Noguera in the next 10 months because we kind of got a hammer over you, okay? I'm concerned that you make good decisions in the future. Okay, 2 years from now, 3 years from now, you have to make good decisions. One of the good decisions is you have to follow the no contact. That's direct or indirect. So just avoid social media in general. Okay. 2, I don't know your relationship with alcohol. We're going to find out. Okay. Most people come in front of me with alcohol or drugs because they drop dirty, and then we know there's a problem, and we start working on the problem. I'm not concerned about you over the next 10 months. Because it should be harder to get drugs and alcohol in jail, okay? I'm not naive to the process that you can, but it should be harder. We want to fix that, okay? We want to fix that. And part of this is to appease, I shouldn't say appease. This is a very emotional situation. You know that, Ms. Woods knows that, and we don't always act at our best when we're in an emotional situation. That being said, part of this order is your conduct. Okay, so you have to abide by what the court says. I trust Mr. Neves has a handle on this. I know Mr. Neves, and so I trust he has a handle on this. So I'm going to fashion my judgment in relation to the judgment of sentence, with the understanding that the more I see of you, the more we got a problem. The less I see of you, the better. You must have better things to do on a Thursday morning with your time than see me. But if you want me to get involved in seeing all this, so be on your best behavior. I would say for the next month, okay? Because that's part of the order. All right. So I'm going to order the defendant spend 80 days in jail. That's given for 1 day previously served. Will suspend 80 days upon successful completion of probation. We have fines and costs of $100 fine, $100 costs. So for $200, and then $200 on the second domestic violence, $200 fines and costs. Crime victims' rights fee on the entry without permission, $75. State minimum court cost fee of $50, and then oversight probation for 10 months at $30. And I'll give you a grand total on that. So on count one, it would be 200 plus 125 plus 300 equals 625. And then on count two, the domestic violence, it's 200 state minimum court cost of $50 for 250. Those can be over, that can all be paid. So it's $875 can be paid over the course of probation. You're placed on probation for 10 months. 769 4A is granted. You're to have no contact, direct or indirect, with Secura Woods or to be within 2,000 feet of where she lives, works, goes to school, without any consent, without your probation's officer's consent or my consent. No assaultive or threatening behavior. No use of possession of alcohol, marijuana, or controlled substance without a prescription. Submit to random PBTs and or your analysis as directed and pay fees. You can talk to Mr. Neves, but that's a part of the order because we've got to find out. We got to find out if there's a problem, okay? No bars or nightclubs. You are to complete following rehabilitative services, pay fees, and provide proof of completion to the court. Any domestic abuse training, usually it's a class. You should take that. GPS is going to remain as a part of this for the next month, okay, for 30 days. After a month, this can be revisited. I'll let you talk to Mr. Neves. You can talk, he's going to talk to Ms. Woods, make sure there's no, so that's what I mean by be on your best behavior for the next 30 days. If you violate that, then we're going to be back in here. And I mean, that's more than a technical violation, okay? Which means that I can send the 80 days right off the bat, okay? That's what I'm talking about is be on your best behavior. Obtain and maintain employment should not be an issue. Not purchase or possess firearms, ammunition, or weapons of any kind. If you go one floor down, you'll see Mr. Neves. He can make sure that you're in contact with him via Zoom, set it up, and then you will get to hear from him when the first random PBT is ordered. Do you have any questions concerning the judgment of sentence, Mr. Milks?
As it indicates, my client works at Applebee's, which does serve alcohol, Your Honor.
Right.
Could she still work there?
Yeah, so I will place as far as not use, possess, or alcohol, marijuana, or controlled substance, or no bars or not bars or nightclubs, unless it's work related.
And nothing further, Your Honor.
That I will tell you, it's been my experience that work related means you have to go back. And if you're in the bar area, it's really easy to regress. And then you regress, and then the next day you have a test, and then we got a problem. Okay. And that has been my experience. So act accordingly. All right. All right. It's just I've had 2 or 3 who work in a restaurant format with a bar, and they've come back and they've indicated that a patron or someone bought them a drink, they drank not thinking, and then they tested dirty, and now we know you got a problem. Allow us to fix the problem if there's a problem. All right, ma'am? All right. Mr. Garrett, do you have any questions concerning the judgment of sentence of the court? All right. Right, I will. With the 17th, I will sign the judgment of sentence. We'll probably make it look pretty. We can print a new one out. Because I wrote in there, no bars or nightclubs unless work related, which goes to your employment. Anything else for the record in 25-01385, Mrs. Allen?
Not for the people.
Mr. Milks?
No, thank you, sir.
All right, you're all set, Ms. Nagara. Thank you for your appearance today. And I'll give you the, I did right, and that's gonna be. Then give me the other one, and I'll just. I'll read some of that. Oh, yeah. Yes, is that the
Yeah.
for Gladwin County?
Take that and journey downstairs.
All right, Mrs. Zell, where did you want to go next?
We have Mr. Cancino brought up, so I think we can have.
All right. All right, so we're on the record in docket 25-00593. That is people of the state of Michigan versus Jacob Cancino. Will the parties please introduce themselves to the record? Mrs. Allen.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Ms. Donlin.
Assistant Public Defender Sarah Donnelly on behalf of the Attorney of Record Rob Palmer, who can't be here, for the defendant Jacob Cancino, who is standing to my right.
And sir, you are Jacob Lee Cancino, is that correct?
Yes, Your Honor.
All right, thank you. This is the time set for a sentencing in the matter. Ms. Zell, is there any restitution in this matter?
We have not received any information on restitution. Your Honor.
All right. Ms. Donnelly, have you had the opportunity to go through the pre-sentence report with Mr. Cancino?
Yes, I have, Your Honor. In regards to additions, deletions, and corrections, obviously the probation officer, I don't think it's, I would imagine that this should be required to be included, but it's not, it doesn't mention how Mr. Cancino is on parole in the report at all. So I think that is an oversight that should be included.
Right.
He's on parole through the 8th Circuit Court. He on a controlled substance and operating when intoxicated third offense, possession of meth. And they do have a hold on him right now.
All right. With that understanding of I'm going to clarify it as an addition that that Mr. Cancino's on a parole hold through the 8th Circuit Court. Is that a fair statement, Ms. Donnelly?
Yes. And with that, no, we have no other needs for any additions, solutions, or corrections.
All right. Allocution, Ms. Donnelly.
Thank you, Your Honor. In regards to the recommendation, we would just like the court to consider the fact that, well, I mean, the recommendation, let's just put it on the record, the recommendation is probation, but again, Mr. Cancino's on a parole hold, an indefinite parole hold, because not just this case, but a case that is basically kind of tied to this, it's a home invasion, first degree with the habitual offender notice on it. So After reviewing that case, Your Honor, there is a strong possibility that Mr. Cancino returns to prison. So with that, I don't believe it'll be appropriate to have Mr. Cancino go through all that, and then at whatever point he's released, it might be with parole again, that he also comes back to the 54A court to do probation. He already has 145 days credit on, I believe, a 1 year maximum offense. So for those reasons, Your Honor, we would ask the court to consider giving him time served. Or if the court would like to give him the full year. And like I said, we don't know when he's going to get out. Obviously, he could get out sooner than that. But again, based on my understanding of the facts in his other case, which is kind of tied to this one, it's looking like there might be more in prison, Your Honor.
Oh.
So we just like the court to consider that.
All right, thank you. Anything concerning the JOS judgment of sentence, Mrs. Zell?
No, Your Honor, we would leave this to your discretion. Thank you.
All right, Mr. Cancino, anything you'd like to say to the court before the court passes sentence?
Yes, Your Honor. I understand I made a bad decision that day. It was an accident that I confused the phone from my phone. I was under the influence, and it was a bad judgment call in my behalf. And I would apologize to the victim. And I was at work, and I had no intentions of taking somebody else's phone. It was an accident, but I know under the circumstances of me being under the influence that I didn't act on it correctly, and I didn't even understand at the time that I had a phone, somebody else's phone in my possession. And before I was able to even bring it back, the cops were at my apartment. And I understand there's not much I can do about that, but I do apologize for the situation.
All right, I'm inclined to agree with your counsel, okay? That probation is another term of sentence. And you're looking at another parole hold on another sentence. And I'm inclined to agree with that. I don't think probation on this case is an answer for you. There's an answer for you, okay? I think you know it, and I think you're well aware of it. Whether you choose that path or not, I can't help with you. I can't help you with. But I am going to sentence you. I'm not going to follow the recommendation of the judgment of sentence, just because if everything works out the way it does, there is a parole hold on you, and you should be collecting time on this file also, as opposed to just getting a probation, so that you can't get on probation because there's a parole hold on you, and you're kind of stuck between the intricacies of the system. So I'm going to sentence you concerning this matter to spend 300 days in jail, credits given for 145 days previously served. And that would cover, so that's 10 months, right? So that's an extra 10 months. So you'll do an extra, you pretty much got 6 months in on this, okay? The extra 4 months is to get this parole stuff started and to see where you lie in that in regards to your parole hold, all right? But I am going to spend 300 days in jail, credits given for previously served. There will be no probation. I'll strike probation and strike any other term or condition recommended. The fines and costs on this, I'm going to waive any fines and costs, waive the crime victims' rights fee, and waive the state minimum court cost fee. You've done 145 days in previously served. You have 300 left on your record. You'll get your parole hold, and then you can start fresh. All right. You won't have anything referred to collections or anything. I've waived fines and costs, waived crime victims' right fee, and state minimum court cost fee. So at some point you can get out and start, doing what you need to do. Some of the issues involved. So it's going to be dependent upon you to take advantage of it, right?
I understand.
All right. So that's the ruling of the court. Anything concerning the ruling of the court, Mrs. Zell?
No, Your Honor.
Ms. Donlin?
No, Your Honor, thank you.
All right, Mr. Cancino, good luck to you.
Thank you, Your Honor.
You can rip that up.
It's not.
There's no way.
And we're ready on Ariana Rios.
All right. And that, Ms. Donnelly, thank you for bringing that to the court's attention, the parole hold, because that makes a huge difference on how I treat that case.
Especially on a 10-year offense, like possession of meth anyway.
Yeah, it's
1 year,
just-
8 months.
Yeah, it's just, there's a lot going on that file.
And like I said, I read the file.
The file check.
I do, that's Mr.
I'm wondering.
And then this is Ms. Rios. All right, so we're on the record in docket 25-01094. That is people of the state of Michigan versus Ariana Rios. Will the parties please introduce themselves for the record? Mrs. Zell.
Thank you, Your Honor. Gabrielle Izal, Assistant Prosecutor for the people.
Ms. Don.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Ariana Rios, who is standing to my right.
And ma'am, you are Ariana Esperanza Rios, is that correct? All right, thank you. This is the time set for a sentencing in the matter. Mrs. Zell, is there any restitution that should be brought to the court's attention?
There is not, Your Honor.
All right. Ms. Donnelly, did you have the opportunity to go through the pre-sentence report with your client?
I did, Your Honor, and I have no need for any additions, deletions, or corrections. Oh, my.
All right, allocution, Ms. Donnelly, when you're ready.
Thank you, Your Honor. Oh, no, wait, it's not the right charger. I don't know where my charger is. Okay. Thank you, Your Honor. In regards to the recommendation, of course, Ms. Rios's attitude, I do greatly appreciate that she can see that her decisions, she made poor decisions and why. Obviously, what we have here is a very young woman, no previous criminal history. I mean, only 18. So, mistakes are bound to happen, and sometimes those mistakes have consequences like this. But I appreciate that Ms. Rios accepts responsibility, and she's learned from this, and I believe that she's a great candidate for probation. I wish the court would follow the recommendations, put her on a term of probation for 6 months with the Home's Youthful Trainee status, so that she can earn the ability to keep this off her record. Thank you, Your Honor.
All right, thank you. Mrs. Zell, is there anything on behalf of the people before I hear from Ms. Rios?
No, Your Honor, we leave this to your discretion.
Thank you. All right. Ms. Rios, is there anything you'd like to say to the court before the court passes sentence?
No.
All right, thank you. All right, so this is for a guilty plea taken on May 15, 2025 to attempt R&O. I don't have any previous criminal history to speak of. Are you still employed at Applebee's?
I work at
What's that?
Amazon.
You work at Amazon now?
Yeah.
All right, perfect. All right, it is based on the guilty plea, I'm gonna order that you spend 2 days in jail, credits given for 2 days previously served. So there'll be no upfront jail. Fines and costs. $100 fine, $100 cost for 200 on the fines and costs. Crime victims' rights fee of $75, state minimum cost fee of $50, and then you're placed on probation for 6 months. Which is $505 total. You're placed on probation for 6 months via Zoom. Your probation agent would be Jody Bayless. And you should check in with Ms. Bayless to find out what is the appropriate number, Zoom number, pursuant to the order, okay? 6 months on probation. 6 months of probation means it's just another form of sentence, all right? So what I'm gonna cover now, you really need to be on your best behavior, all right? HYT is granted, and that's really the carrot, okay? That means this is abstracted in a whole different way. than it is now once it's granted. Okay, so that really is the benefit of the judgment of sentence, as I see it. The YTA is granted. No assaultive or threatening behavior. No use and possession of alcohol, marijuana, or controlled substance. Submit to random PBTs and/or urinalysis as directed. No bars or nightclubs. The probation be for 6 months. Complete following rehabilitative services, pay fees, and provide proof of completion to the court. I think we all could use anger management. Okay, so that cognitive behavioral therapy, that you explain that as a good class for you to take and to learn from. Obtain and maintain employment. You indicated you work at Amazon, and not purchase or possess firearms, ammunition, or weapons of any kind. So really, it's 6 months just to make sure that the attempt RNO doesn't become a thing. Okay, if it becomes a thing, then I get into your life, and you don't want that to happen, right? This 6 months is the sentence, but what it really means is just be on your best behavior. We're going to look at this as a learning experience, right? This is a learning experience because you're going to have an attempt RNO on your record unless the YTA is granted and then subtracted differently. And so you're already starting down a path we don't want you to start down. All right. That I guess that's the key here. I don't want to have to look at a criminal history 5 or 6 years from now and indicate I wish they would have paid attention when they were 18 or 19. I know you don't feel young as 18 or 19, but trust me, you're still young at 18 or 19. So let us help you, okay? All right. I'm going to have this made all pretty and look pretty. Anything towards the factual basis, anything concerning the judgment of sentence, Mrs. L?
No, Your Honor, thank you.
Ms. Donnelly?
No, thank you.
All right. I would go down, Ms. Bailey, I think that
Ms. Bayless is here.
is right here. You can see, she can tell you where to meet. That's the person who can violate you. So that's the person you really want on your side to say, I'm doing everything I need to do. All right, ma'am? Okay, you're all set. Thank you.
Yeah, it was. I mean, we don't follow this.
No, it helps to have a probation agent in the room. You can't do your actual work. Yeah, well, we're gonna take, I think we did Wheaton already, right? All right, Mrs. L, what case did you want to call next?
So we are ready on Ethan Blackwell and Jacoya Wilson, who are technically co-defendants. I am going to be asking, however, to treat those separately today.
All right. And then Ms. Wanji's here on Mr. Lindsay
Yes, and Blackwell too.
and Blackwell. All right. Those are the two co-defendants. So which cases are we calling?
If we could start with the Blackwell case, and then if you want to call the co-defendant case with that as well, that would be
All right,
Jacoya Wilson.
so that will be Blackwell and Lindsay and Wilson. All right, so we're on the record in dockets 25-01378 and 25-01377. That is people of the state of Michigan versus Ethan Blackwell and Jacoya Wilson. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the people.
Ms. Wanji.
Good morning, Your Honor. Melanie Wanji, Assistant Public Defender for Mr. Blackwell. I'm covering for Mr. Kaplan.
And Mr. Johnson.
Good morning, Mayor. Please, this honorable court, Kareem Johnson, appeared on behalf of Ms. Wilson, who's present in court, standing behind me.
And ma'am, you are Jacoya Wilson? Okay, thank you. This is the time set for a preliminary examination. And then it's my understanding that then you can supplement after. Mr. Blackwell is in Macomb County. And that's your client, Mr. Kaplan's client, and Macomb County says he's not in Macomb County, but everything computer-wise seems to say that Mr. Blackwell is in Macomb County. So I'm uncertain about that. I'm uncertain about where Mr. Blackwell is. Mrs. L, you can supplement in regards to Mr. Blackwell.
Thank you, Your Honor. That is my understanding as well. At this time, since our understanding was that he was in custody and is in custody somewhere, we would just be asking for an adjournment today. However, I will defer to Ms. Wanji to make additional record.
Ms. Wanji.
You know, I checked where he was from the Vine and couldn't find him. It's my understanding that he's in rehab. In inpatient treatment.
Oh, he's an inpatient. What?
Inpatient where?
Where? Do you know where? All right. All right. We have him in Macomb County.
You can contact his mom.
All right. But Macomb County says he's not there. So I don't know where he is. So that's my problem with Mr. Blackwell is he's not here. He's listed as in custody, and we're getting conflicting information on where he is. Is that your understanding, Ms. Wanji? You've heard recently that he might be an inpatient.
Yes, Your Honor.
Right.
No way for me.
Yeah, we don't have. So, Mrs. L, what would you like to do on Mr. Blackwell?
Your Honor, if I could change my request and ask for a 48-hour hold on a bench warrant here to try to get confirmation of where Mr. Blackwell is, and then to give that opportunity for that information to be found before that bench warrant is issued. This is probably the third time this case has been reset due to the fact that we could not find the specific defendant, and I believe we need to start moving the case forward.
If I may, Your Honor, from the notes, he was on probation in Macomb County, and it's from the notes that I have, he was going to be sent to inpatient treatment. If the judge ordered him to go to inpatient treatment, I think that he cannot be disobeying the judge's order and come to court here.
All that's true. I have him in custody. I don't know where he is. Macomb says he's not there. So I'm going to grant an adjournment in this, but here's my problem. We have a good cause adjournment on May 29th. We have a fail to appear because the defendant is in Macomb County on June 5th. So needless to say, on July 17th, defendant has failed to appear again. And now he's either inpatient. So we got to get some information. We just, we got to figure out if he's an inpatient, where he is an inpatient. Macomb County should know that. They're not sharing that information for whatever reason. But we got to get him here for the next date, I would think. And these are co-defendants, but one is an R&O and one is an assault with intent.
Correct, Your Honor.
So I can see why they can be severed concerning this matter. But I will grant the adjournment. I can't issue a bench warrant because I really just don't know where he is. If he is in inpatient at the request of a Macomb County judge, I don't want to play. I just want to know where he is. Okay. So let's reset this prelim for good cause. Obviously, we can't go forward without the defendant, or it makes it difficult to go forward without the defendant. Defendant may be in inpatient or maybe at the Macomb County Jail. We've tried a writ from there. If the writ doesn't work and he's not being writ over, I would think he'd be an inpatient, but we don't have any notice of that. Nobody has told us that. And Macomb Jail is not playing with us. They're not playing well. So we'll adjourn for good cause on that file 25-01378. And that we will set, I would think, for this Giselle, what time frame are we looking at? Now we're gonna sever the cases. So
Thank you, Your Honor. With the uncertainty of it all, we have adjourned multiple times for almost a month-long period both times, and we still haven't been able to come to that conclusion. I would ask that this adjournment remain under the 30-day mark.
all right. So let's do it under 30 days. Ms. Wanji, any comment? And if your client is Mr. Kaplan's client is in inpatient, let us know where. Okay? We got to know where, because we're kind of in a void right now. Will grant to sever this case, and then we'll grant the adjournment for good cause. Within 30 days.
August 7th at 9.
August 7th at 9 o'clock.
Thank you, Your Honor.
All right, so that's on file 25-01378. We'll set for August 7th at 9 o'clock. And then we still have the co-defendant file 25-01377. Mrs. L, this is the time set for prelim. How did you want to proceed on that one?
Your Honor, at this time, the necessary witnesses in the people's case have failed to appear. They were subpoenaed for today's date, and they have been here for the last two preliminary exams that have been set. At this time, I'm unsure why they are not here. We would be requesting an adjournment today to check in with those witnesses and see why they weren't here. However, we do expect a motion from the defense today. If that motion is to be granted, we would just like to put defense on notice that this case may be reissued upon contacting those witnesses.
All right, thank you. People are unable to proceed. Witnesses did appear, but then left. Would that be a fair statement?
No, Your Honor, they were not here today at all. They were here on different days. I want to make that clear.
All right, so witnesses failed to appear at hearing today. Motion from the defense.
Yeah, we ask this matter be dismissed without prejudice. My client understands that it may be brought back if people choose to do so.
All right. So I'm going to have printed out on the defense motion to dismiss without prejudice. Ms. Wilson, what this means is the people could reissue if they choose to, and most likely if they contact the victims and they have an agreement to proceed, we're going to start this process again. So you might want to have Mr. Johnson's number close or some levels,
Don't
because,
worry about that.
yeah, so you, but I will have usually I say that's a default, a dismissal without prejudice is a default. I'm uncertain on this one. This may affect your ability you'll have to be rearranged and it'll all be reset concerning the appearances of the witnesses.
I do have a question.
Sure, and let me get that so I can. All right. All right. Any question, Ms. Wilson or Mr. Johnson?
No, Your Honor.
Is your question in regard to no contact or GPS? Because I'm going to indicate that right now. There's going to be a no contact or there's a no contact.
Myself,
Okay.
I really do. I need help from me because I'm the one who's being harassed and I don't know what to do. Like, people keep telling me to go to the
Call the police.
I did.
Call-
I gave my video footage, ring cam footage. They broke my
Yeah,
ring
you're
camera.
going to have to call and make a police report. That's the one thing that and then go through those processes. You should keep and carry a copy of the dismissal, right? Because I'm going to sign the dismissal right now without prejudice. And so it's going to take about 4 to 5 hours for this to purge from the system. So that's my fear is the case is dismissed, but you'll have 4 or 5 hours that are going to be purged from the system. So carry this with you just in case. All right. There's not a GPS, so we don't have to contact any private entity, but there's a no contact order. And I will, at the motion for defense, I will grant the motion to dismiss without prejudice. And then you should keep a copy with you just for your records. Because what I'm afraid of is in the afternoon, you'll get approached and you should have something with you to show this case has been dismissed. All right, ma'am. If you are still if there's still contact, unwarranted contact, you should contact the police again. And it's okay to be a nuisance. All right. All right.
Thank you.
All right. You're all set, ma'am.
Have a good day.
You too. Ms. Wilson. And then Miss Wanji, you're on Miss Lindsay.
Yes, Your Honor.
And I have, who is that on? So is Lindsay coming from the jail?
I was told he was not.
Let's see who that, sir, because Mr. Howell was previous. Sir, from the jail, could you identify yourself?
Isaiah Murray, they told me to come here.
All right, Isaiah. All right, I think you're in front of another judge. What's your last name, sir?
Murray, Murray.
Urray.
Am I in the wrong one? Y'all in the wrong court. What is this for?
He's mislabeled too. All right. That'll take care of that. All right. So we're on the record in docket 25-01245. That is People of the State of Michigan versus Jakai D. Lindsay. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the People.
Ms. Wanji.
Melanie Elviwanji for Mr. Lindsay. It's my understanding, I have the note that he's here, but I don't.
He was.
I checked him in earlier, Judge.
You checked him
He
in?
was wearing a green sweatshirt, sleep back. I can go see if I can find him.
Yeah, we'll check the floor to see if he's here. I do see this as not assaulted. And he did waive his 21-day rule, and it's a previous good cause adjournment. But if he, so he knows where to come.
He knows.
Yeah,
It's my understanding that the note said that he called the office because he's here somewhere.
All right.
And if the court officer said that she checked him in, I would believe.
Yeah, I would agree.
The intention today was to ask for an adjournment, as far as I understood. I would be willing to move forward in that way after hearing all of this.
All right, and let's see if he's here, and then we may waive his appearance if he's not.
I think that would be fine.
Yeah. And Ms. Wanji, that's your understanding. If he's here, we'll place the adjournment on the record. If not, we'll waive his appearance. All right, because he knows where to come. We have a good cause adjournment as of May 15th, and then he waived the 21-day rule on June 12th. So Mrs. I'll allow you to make a record.
Thank you, Your Honor. At this time, it's my understanding that Mr. Lindsay was here earlier today, did check in with the courts, and did call the court call the public defender's office to let them know that he was present here. It is about 2 hours after his case was set, so it's understandable if he is not here at this time. We would ask to waive his appearance today so that we can adjourn this case. Mr. Lindsay does have a new file that is making its way through the system. I believe it was sworn to either yesterday or is being sworn to today. The goal is to have these cases set together. However, we don't have a date for that new case yet.
All right, and that case hasn't been arraigned yet?
It has not, Your Honor. I can tell you. 1 second. On that new file, it looks like there are 5 charges. The lead charge is a possession of cocaine or heroin.
Okay, so that'll be a summons. Let me see how far out the magistrate's docket is.
It's my understanding Mr. Palmer is already made aware of this new case, and that is why we are asking for that.
All right, and we're doing that so we can have some date for resetting the prelim.
Yes.
Do you want this reset? Well, let's figure out.
She is setting into August 15th and beyond. So it would be at least August 15th before they would come up for an arraignment.
Which is
depending on
30
when
days away.
Sworn to and all that other stuff.
Why don't we set it
And he
out?
won't be in rotation.
Why don't we set it out for 30 days and we'll figure out where the case is?
I think that would work. Your
Yeah,
Honor. I
and then,
wouldn't be opposed.
just to figure out where the case is, and we have this one. We should actually have the new one. Let's set it afterwards. I just want to make sure both cases are set together. Is that the week of the conference?
Yes.
All right. So the following week?
August 29th at 8:30. And we'll try to find the other one and match that up. Yep.
So for my understanding, the defendant's already waived his right to a 21-day rule. We're trying to reset this with a new file, so there'll be a global resolution on both files, and we've set for August 29th at 8:30.
Thank you.
Anything towards the waiver, we know Mr. Lindsay was here, a waiver of the appearance or the new date of August 29th, Mrs. L.
No, Your Honor, thank you.
Ms. Wanji.
No, Your Honor,
All right, thank you. You're all set. All right, and Miss Gazelle, do you have anything? I think it's all civil this afternoon.
Yeah, I think that's it. for me
You're all
today.
set, okay,
I'll be here all day tomorrow.
okay. Similarly tomorrow. We'll see ya. Thank you, Miss Wanji.
Thank you, Your Honor.
Ms. Bayless, thank you for covering.
Oh, yeah, no problem.
Well, she's coming back.
I'll say, I'll be in the
We only
afternoon.
have one actual court recorder here,
Really?
or not court recorder, court officer. It's Sierra,
Sierra's here, David's gone, Megan's
Meg's gone.
gone,
and the other one's just gone.
and the other one's not here. And we're setting the other one for interviews.
Yeah.
Do you want me to take the tag off the black hole?
No, because leave it on, please. I'm gonna have to.
Thanks,
do
Mrs.
another
L.
Okay.
See you all tomorrow.
Yeah, I don't think he's there though.
run. Well, they can do,
Oh,
yeah, I'm just gonna have them do our,
because I searched him finally. He's not pulling up.
I searched that and I searched MDOC and he's not coming out, but to do our due diligence, we'll send another writ. I'm gonna have
I
Susie put
bet
on there
you-
inpatient.
I bet she's inpatient.
I do too. And you see
Huh?
Susie can put inpatient on the writ.
So we gotta find out where he is, so we can polycom.
I know who he always when I looked. I can email him.
That'd be great.
Okay.
Oh, that's a good idea.
Yeah.
Yeah.
I'll send an email when I head to my
Oh, that would be
office.
super helpful. Thank you.
Hopefully she responds.
Well, all you do is try.
All
Technically,
right.
the attorney should be working harder on this than we are, but
I mean, that's fair.
on the other flip side of it.
Yes, on,
He
on,
reviewed us before I say something.
well,
Yeah.
on this floor. Eric, we be lying.
So. Get your phone so right before, please. And right now, we're just kind of hanging out. They're still finishing up the hearing in the courtroom, and then we'll get in there and stuff.
Is there any way to, they're gonna take a break after the criminal matter is over?
Good afternoon, everyone. Judge is on his way to take the bench, and once he logs into our on-base system, we will start calling the 130 cases.
Pamela Payne, what case are you here on?
I am here for Manorborn, and it is Patrice Clark. Case
Patrice
number
Clark?
correct.
And you're here for, are you here, what, so you're here on 2502770?
Correct.
And you're listed as Pamela Payne.
Correct.
Is that your name?
Yes, that is
But
my
you're
name.
not, I don't have anybody Or are you representing the plaintiff in the matter?
I am the property manager here at
Okay,
Pine Brook Manor.
all right. Perfect.
Milk go in the refrigerator. She ain't gonna drink it. It's wasted. Milk go in the refrigerator.
Mr. Gould, you'll have to mute
Oh, I'm
because we can
sorry.
hear everything that's coming from your
Yes,
computer.
I'm sorry. I'm sorry.
Okay. All right, and then Mr. Burnett, are you here for, who's here for Lansing Automakers? Is that you, Mr. Burnett?
Yes, Your Honor.
All right. Let's go ahead and call that case. So we're on the record in docket 1205053. That's Lansing Automakers versus China Gibbs Hinton. Appearances for the record, Mr. Burnett.
Yes, good afternoon, Your Honor. My name is Joe Burnett. I'm filling in for Tim Smith on behalf of Lapke.
All right, this is the time set for a motion to show cause. I think I saw, or I remember seeing, there was we set this as of May 27th, and the order was to follow concerning the show cause. And it appears that Ms. Gibbs Hinton has failed to appear for the current motion for show cause. I do have an order that's been submitted giving 9 days in order to service by attachment. Is that the same case, Mr. Burnett?
I believe so, Your Honor. Let me confirm here.
Let me make sure, because I don't want to, but I have a motion, a show cause motion. Yeah, that would be for China M. Gibbs Hinton has failed to comply, and a failure to appear for contempt hearing may result in a bench warrant being issued for your arrest. A copy of this order must be served by mail on the person ordered to appear at least 9 days before the mailing. Is that the order that goes for the non-appearance today?
Your Honor, I merely have just the standard motion and affidavit to show cause. The proof of service that we have for that shows that she was served by mail on June 12th. I don't have anything other than that, Your Honor.
All right, I've got that. That's my confusion, I guess, is I have an order to sign, and then I was thinking that would be in anticipation of this hearing. And she has been served. But if you want to do an order for show cause, I do an additional order. I'm uncertain.
Your Honor, I believe, sorry to interrupt you. I think I am seeing
Sure.
what you're seeing on page 2 with the paragraph 5, copy of this order must be served by mail
Right.
on the person at least 9 days before the hearing with your signature on June 11th.
Yes.
Yes, okay. Yes, I have that, Your Honor.
All right. So is that representative of today's hearing, or is that or that's in anticipation that Ms. China Gibbs Hinton would not appear today?
That was for today's hearing, Your Honor.
Okay. All right. So that settles any confusion I have in this matter. All right. So it appeared that this was scheduled for 1:30. It is now 1:57. I'll write those times down. 30, 1:57. I do not see a China Gibbs Hinton in the Zoom courtroom or physical courtroom, and nobody appears to be in the physical courtroom or in the hallway to that name. Mr. Burnett, it appears that Ms. Gibbs Hinton has failed to appear today. How did you want to proceed on the motion to show cause?
Your Honor, due to the defendant's failure to appear, we would request that a bench warrant issue for Ms. Gibbs Hinton. Her balance is fairly substantial. It is 29,780. We would request a cash bond. I don't recall your court's custom if you prefer a percentage or a flat rate, but we'll leave it to your discretion, of course.
All right, thank you. We'll do what is the full amount of the amount owed on this?
Full amount, Your Honor, is 29,780.
Right. Let's do a 500 cash surety. And as you know, she'll most likely be that's PR'd in 3 days. Yeah, she'll be PR'd in 3 days on this on the show cause warrant. But I'll accept for the non-appearance of the show cause hearing. I'll accept the motion for show cause and warrant from Mr. Smith.
Okay, thank you, Your Honor.
All right. So that's all for the record in 1205053. Let me make some notes and I'll call your discovery hearing. And I don't see anybody here on the discovery hearing either.
Okay.
All right, so you guys got a balance of 28.44 and 43 cents that's currently due. Are you going to be able to get that paid?
All right, Mr. Burnett, we'll call docket 1801081 GC. That is Lafque versus Howard Sealer. And I have a note from civil indicating that the proof of service, no proof of service was filed as of July 9th for the discovery hearing. Do you know anything about that, Mr. Burnett?
Your Honor, I believe we were not able to obtain service for the defendant on this case, Your Honor. So, yeah,
Did you want me to adjourn for alternate service?
Yes, Your Honor, that would be very helpful. Yes.
So we will adjourn the discovery hearing. And what's the time frame for that alternative service, Mr. Burnett?
Your Honor, I apologize. I don't have a great answer for you there.
So yeah, I'm going to say about 6 weeks.
Okay.
All right. So we'll adjourn discovery hearing and allow a service to be perfected. We'll probably need a motion for alternative service. And we'll set for September. All right, so we've reset this discovery hearing in order to perfect service or for a motion for alternative service to be signed in the interim for September 11th at 1:30.
Thank you, Your Honor.
Thank you. You should be all set on 1801081. And I'll call your next case of 1801148. That is Laff Q versus Nicholas Hutenlocker. And then it would appear that the defendant failed to appear for Judge Alderson in 2018. And this is a discovery proceeding. This was set for 1:30. It is now 2:04. It appears the defendant failed to appear. Appearances for the record, Mr. Burnett.
Yes, good afternoon, Your Honor. My name is Joe Burnett. I'm filling in for Tim Smith on behalf of LAFQ. I do understand that Mr. Smith and Mr. Hutenlocker have been in contact, and I believe he even made a payment on his account. The problem, Your Honor, is we haven't received the documents that we requested in the subpoena. So I think I didn't mean to cut you off if you had more to say, Your Honor, but I think we'd be asking for a show cause on this one, Your Honor.
All right, so I'm going to indicate the defendant failed to appear and for the discovery hearing, and we're gonna do a motion for show cause. You said myself. Motion for show cause concerning the non-appearance, and then we can go from there. We'll go from there to see what happens at the motion for show cause, and then whether Mr. Hutenlocker has any contact with your office. But the civil department will set this for motion to show cause for the non-appearance today.
Okay, and we will file that, and we'll go from there. We appreciate it, Your Honor.
All right, we should be all set. Is anything else on behalf of Mr. Smith, Mr. Burnett on? I think that's the end of your cases.
I believe so. Yes, that's all I have.
All right.
Your Honor. Thank you.
All right, thank you. And then Mr. Kent's.
I'm sorry, Your Honor, were you speaking with me?
All right, so are you on? We're looking for a representative of Grassel and Richardson.
That would
me,
Judge.
All right, all right.
Judge
All right,
Mall.
so Mr. Mall, let's call your case. So we're on the record in 2408554. That is Grassel and Richardson versus John Sonnenberg. Will the parties please introduce themselves for the record? Mr. Mall.
Good afternoon, Judge. My name is Ed Mall, M-A-H-L. My bar number is 27115, and I'm standing in for the plaintiff on this thing this afternoon.
All right, thank you, Mr. Mall. Is there a representative of John Sonnenberg? John Sonnenberg? I do not see, so I'm going to indicate for the record that I do not see a John Sonnenberg in the Zoom courtroom. This was scheduled for 1:30. It is now 2:08. And I do not see a John Sonnenberg in the Zoom courtroom, there's nobody by that name in the physical courtroom. And there's been nobody answering to that name in the hallway. It would appear that John Sonnenberg has failed to appear for the motion to show cause. Mr. Mull, how did you want to proceed?
Your Honor, we are asking for the issuance of a bench warrant. The judgment was entered for only about $3,000. So whatever bond you feel is appropriate.
All right, we'll do $2,000, 10%. On the matter, understanding that Mr. Sonnenberg will probably be released at PR'd after 3 days. It would be my best guess. All right, Mr. Mull?
All right, thank you, Judge.
All right, and then you'll follow up with an order to that effect for the non-appearance for the motion to show cause.
Yeah, we'll send you a bench warrant.
All right, sounds great.
Okay.
All right, anything else for the record in 2408-554, Mr. Mull?
No, Your Honor. Thank you for your courtesy this
All right.
afternoon.
All right, thank you for your appearance. You're all set.
Okay, bye-bye.
I have strong. Why do I have laugh QV strong? It's a Judge Buchanan case. Let me put on just my cases. All right. I just have Judge Buchanan cases. There we go. I don't know why that happened.
Because.
All right. Yes. All right, ma'am. So, ma'am, you are Damis Rodriguez Cruz? All right. So, Mr. Scheiblen, we'll call your case. Oh. Okay.
Hello.
Just so you know,
Yes.
Mr. Scheiblen, we have a translator, and if we're going to put you on in it'll allow you to talk to the tenant in this, or the defendant in this matter. We're going to place the translator on iPad so you can have some conversation, understanding that this is a free trial. All right?
Understood.
All right. So, the interpreter, please state your name and spell your first name and last name for the record.
Susana Villarreal, Susana Villarreal.
Okay, please raise your right hand. Do you solemnly swear or affirm that you will truly, accurately, and impartially interpret in the matter now before the court and not divulge confidential communications, so if you got under the penalty of perjury? Okay. Just let me know if I get going a little fast. All right. So we're on the record in docket 25-02023. That is HZCNAC Incorporated versus Damis Rodriguez Cruz. Will the parties please introduce themselves for the record? Mr. Scheibelben, and I don't know if I've been pronouncing that correctly.
I thank Your Honor, it's close enough. My name is Anthony Shivelbein. I can spell that phonetically for the record if you need. P number 88196. Here on behalf of HCCNAC. My law office is Satilli and Barilli.
All right, thank you. And ma'am, you are Damis Rodriguez Cruz. Yes. All right, this is the time set for pre-trial in the matter. Making sure all right, this time set for pre-trial in the matter. I would assume the parties have not had the opportunity to speak to one another since there seems to be a language gap and a translator here. I would provide Ms. Rodriguez Cruz and the interpreter an arena. I would give her an iPad. We'd set her up on an iPad so you can have some discussions with her. And then if you still want to put the pretrial on the record and have us fill it out, we can do that. But this would give the opportunity to the parties to speak if they choose to. Mr. Shivelbein, do you want the opportunity to speak to Ms. Rodriguez Cruz?
Yeah, I have no problems with that.
Okay. Ms. Rodriguez Cruz, would you like the opportunity to speak to the opposing counsel with the translator present, just to indicate anything, and then we can come back and put the pretrial statement on the record? It's something that we'd print out.
Yes.
Okay. All right. So if you follow my court officer, he'll put you on an iPad, and then once you join the room, I'll put you in a breakout room, and with the translator, you can discuss this, and then we can go out and fill out the pretrial discovery form. All right. So, we're going to put you in room. I know I'm going to mess up your name. Is it Shivelbein?
That's perfectly exactly right. Yes. But I'm happy to go by Anthony to make things easier.
All right. So let's put you in room 1, and then when the iPad's added to the room, we'll put you in room 1. We'll put that in room 1, and then we can come back and put it on the record.
Okay, Your Honor.
So we're looking for the iPad. All right, and then do we have a representative for Manorborn?
Yes, Judge, I'm here.
All right, and we have a Patrice Clark. All right, I'm gonna call your case next, as in the next minute, as soon as I add the iPad to the breakout room. All right, so we're on the record in docket 25 is 02770. That is Manorborn LDHALP versus Patrice Clark. Appearances for the record, Mr. Joseph.
Joe Joseph for plaintiff.
All right. And ma'am, you are Patrice Clark, is that correct?
Yes.
All right. Thank you. This is the time set for a motion to set aside the judgment. I think this would be filed by Ms. Clark. So that would be Ms. Clark's motion. Ms. Clark, did you want to meet with Mr. Joseph on this prior to your motion, or did you want to just go forward with your motion?
What do you mean by that?
I mean, what I mean by that is, well, Mr. Joseph, would you be amenable to meeting with Ms. Clark? If not,
Yeah, Judge,
she can go forward with her motion.
we can meet, that's fine.
All right. So Ms. Clark, the opposing party said that they would meet with you before the motion if you choose, or you can go ahead with your motion on your own. It's entirely up to you, ma'am.
Okay.
So, okay,
That's-
what? Okay,
that's-
you want to go
that's
forward
fine.
with the motion?
If he wants, yeah, if he wants to talk, that's totally fine.
Okay, it's not up to him. It's really up to you, ma'am. If you would like to meet with Mr.
Oh, sure.
Joseph.
Why? Yeah, I didn't understand, but yes.
All right. So I don't think we have a second iPad right now, right?
They're both on Zoom.
Oh, they're both on. You're both on Zoom.
Aren't they?
Yes, they are.
Oh, okay.
Okay. So, Mr. Joseph, Ms. Clark said she'd like to meet with you. I'm going to place you in room 2. And then Ms. Clark, I'll also place you in room 2, and then we can come back and put it on the record. Good call.
Judge.
Yes, Ms. Payne. Oh, you're the property
place
manager.
me in
Do you
room
want to
2
be on that?
also?
Do you want to be in that meeting, ma'am?
Yes, please.
All right. You should get a prompt to go to room 2 also. All right, so do we have a representative of South Tree and Gould?
Yes, good afternoon, Your Honor. Ronald Bach
All
here
right.
for South Tree.
All right. Okay. And Mr. Katz, I think you should be in front of Judge Buchanan.
I'm sorry. I must have gotten the wrong Zoom address.
I think the ID number, I think you're on the docket for Judge Buchanan.
Thank you, sir.
You're welcome. All right, so we're on the record in docket 2502833. That is people of the state of Michigan, or that is South Tree LLC versus Wesley Gould. Appearances for the record, Mr. Bach.
Yes, good afternoon, Your Honor. Ronald Bach here for South Tree Apartments.
And sir, you are Wesley Gould, is that correct?
Yes, sir. I am Wesley Gould.
All right, thank you. This is the time set for a motion to set aside judgment that was brought by Mr. Gould. It appears that comes out of a June 25th default judgment. We were here on a June 25th date, or that's when the judgment comes from. Before we get started, since you're both on Zoom, Mr. Bach, did you want the opportunity to speak with Mr. Gould concerning any of these issues concerning the motion?
I don't know. We could speak after that. I think that's fine.
All right. All right. Mr. Gould, this is your motion to set aside judgment. So you may proceed with your motion.
Yes. For the record, this was a matter of non-payment of rent, and it was because of
I'm not going to relitigate the underlying. The motion is to set aside the judgment, and I think the judgment comes out of a fail to appear. So why don't you address that issue as to why you did not fail to appear?
I failed to appear because I didn't know. I wasn't notified. No, I wasn't called by phone or.
All right. Before we issue the default judgment, we make sure that there's service on the case. And so let's see what our service was that we issued the default judgment on. So it's for June 25th, the default judgment, and service would have been. So it's posted in second mailing. All right. So I have a posted and second mailing that it was mailed to you, and then it was posted, and that's when we did the default judgment. Your indication today is you received neither.
Well, it was posted and mailed, but I didn't get back to my apartment because my wife, she's pregnant, and I've been visiting with her, and so I wasn't even at my apartment when they mailed it, or even some stuff.
All right, but you understand that that's the last address you're to be notified at, and so whether you're there or not, that's why the posting and mail was sent to that address.
Yes.
You're just saying you didn't receive notification at that address.
Yeah, it was notification, but I didn't receive it until I returned to my apartment. Yes, there was notification.
All right. So that's why you failed to appear.
Well, yeah, I mean, you stopped. I didn't complete it, but yeah, I wasn't at the address to receive.
Where were you to receive notification?
I was at my wife's address at 809 Beach Lawn Court.
Should that have been your notification address then?
For the time, I suppose. I mean, yes, it should have been, because I wasn't.
What did the post office have your mail going to?
Well, post office had my mail going to 2300 Beacon Hill and South the 6112 Beachfield. But
the post office had both addresses?
Yes,
because we can confirm that with the post office.
Yes, because even when any case that I have my mailing address 2300 Beacon Hill. So I don't even know, even for any case that I have, I always give 2300 Beacon Hill. So I
All
don't
right,
even know.
but did you contact the post office with that address?
No, I
Because
never.
that's what you do. Doesn't mean the post office knows to send it to that address.
No, I never contacted any post office. I only give my information when I fill out applications or any type of form. That's the only way I give that address out. So I
All
never.
right. Mr. Bach, what is your response in regard to the motion for, I guess Mr. Gould is indicating that he did not receive notice.
Yeah, Your Honor, as you know, this is a motion, an action against the property. It's not an action against him. Process server in all eviction cases goes to the property a number of times and tries to serve the person. If they can't get the person served, they post it to the property, being an action against the property, and not without a money judgment. That is proper. His own text from June 26 to Miss Precious Rogers states that he knows there's papers on the door because we started the eviction process. Now, so he must have known we started the eviction process. He knew there was papers on his door.
Thank you. Mr. Gould, response.
Papers on my door, that was after the fact. Only reason I know that there was a court process because before the papers even get on the door, and I have correspondence to let people know that the court, that they proceeded to try to evict me because of the non-payment of rent, but it was from a failed inspection. And so, but other than that, I notified the property manager and my caseworker of that when I first got a notice in the mail. So it wasn't no notice of any paper on the door. So when I first got the notice in the mail, which was way before the court proceeding and the default judgment, I got one paper saying intent to get the property. And I notified my my case manager and the property manager regarding this. And then they responded.
All right, so I'm going to deny the motion to set aside the judgment based on the lack of notice. I believe proper motion service was proper. We checked on motion and second posting in this matter, and it was set for second motion and posting because the defendant could not be served, and therefore the motion to set aside is denied. And Mr. Bach, you'll file an order to that effect, sir?
Yes, Your Honor.
All right. So that's all for the record in 2502833. Mr. Gould, your motion has been denied. Anything else on 2502833, Mr. Bach?
No, Your Honor.
Mr. Gould, do you have any questions of me?
Yeah, so my motion denied, but I'm not even authorized to even to pay the rent or anything.
Your motion, sir, your motion's been denied. You should probably talk to a lawyer at this time. The motion to set aside has been denied.
So even if the payment has been paid, I don't get the escrow?
In my opinion, your motion to set aside the judgment, so the judgment still stands.
Right, but even if they've been paid regarding the rent?
I don't know. I can't comment on that because I don't know anything about. All I'm indicating is the judgment still stands. It is not set aside, so the default judgment is in order.
So what about the bond that I posted?
I'm uncertain about any bond you've posted.
I posted.
Right, does that goes back to him, or does that go towards what he owes?
I would assume it goes towards what they owe.
All right.
I don't know that.
You should contact the civil department in regards to what your escrow is concerning anything you posted in relation to the bond.
Okay, so you talk to the civil.
So,
you don't have an answer.
Yeah, contact the civil department, and they'll tell you what determination's been made concerning the bond or escrow that you posted in relation to this motion.
Okay.
Okay. You're all set, sir. Thank you for your appearance today. And Mr. Bach, we'll see you. Well, an order to follow in this case.
Yes, sir.
All right. Thank you.
Hello?
You should be all set, Mr. Gould. Thank you for your appearance.
Thank you.
All right, so we're back on the record in 25-02833. That is HZCNAC Incorporated versus Damis Rodriguez Cruz. Mr. Shivelbein, did you have the opportunity to speak to the interpreter and Ms. Damis Rodriguez Cruz in a breakout room?
Yes, I did, Your Honor.
And what, if anything, came out of that meeting?
Both parties have agreed. I got my client on the phone shortly, and everybody's agreed to a consent judgment with the terms of oh, sorry.
And did you want to place any terms of the consent judgment on the record, Mr. Shivelbein?
Yes.
All right.
Mostly for her benefit, but I would be happy to do so. The terms
when you're ready.
Certainly. Let me make sure I have it in front of me. So the consent judgment is going to be for the sum of $9,184.79, which is the remaining principal balance, plus the pre-judgment interest that's already accrued of $1,021.14. This is for a total balance at this point, plus costs of $10,399.88. It's been agreed that the payments will be for $80 per month, and in exchange, my client will be waiving their statutory interest accrual so long as payments are made. So a 0% interest so long as she makes that $80 per month payment.
All right, and then Mr. Shivelbein, to advance the consent judgment to the court, were you looking? Will that be reviewed by Ms. Rodriguez Cruz, or are you seeking authority to sign on her behalf?
No, I will prepare it by my office, and then she's provided an updated email for her mother who filed the previous answer. I will send it to her for both of them to review, and then send, and then we'll file it with the court afterwards.
Perfect. All right. So, and you have their contact information to provide any consent judgment for their review?
Yes, Your Honor.
All right. All right. Once it's reviewed, the order, your order is to follow concerning the consent judgment, Mr. Shivelbein.
I'm sorry?
Once it's reviewed by them and signed, you'll provide that to the court concerning this matter. Is that correct?
Yes, Your Honor.
All right. And then let us know if there seems to be a problem, we can just set it for an additional pretrial.
Okay, I'd be happy to do that, but I'm pretty sure it should go smoothly with my client waiving interest and all.
All right. Does Miss Dimes Rodriguez Cruz have any questions?
No.
All right. All right. Then I will await the order to follow. You'll get to review the order in order to see if it meets with your agreement, the approval, and then you should send it back to Mr. Shivelbein, and he'll advance to the court for the court's signature. Does she have any? Do you have any questions? All right. All right. So I'll wait the order to follow. That's all for the record in 2502023. Mr. Shivelbein, thank you for your appearance today. Thank you for your assistance.
Thank you. Have a good day, Your Honor.
You too.
Your Honor, there won't be another pretrial.
No, not right now. I'm just waiting for them to get the order, the agreement to review, sign, and then it goes to it'll be filed with us. So there should not be another hearing on this file. Thank you.
Los pagos se van a hacer igual, mamita, por el medio del banco, se va a hacer directamente. Cuando ya llegue el correo o mira, ya las quiero. I have an answer.
Give me a second. I think it's like. All right, so we're back on the record in 2502770. And Mr. Joseph, did you have the opportunity to speak with Ms. Clark in a breakout room?
Yes, judges, this will have to move forward for your honor. There's no resolution. She wants more time. I can't give her more time, and that's where we're at.
All right. Ms. Clark, did you, so you should go forward on your motion to set aside the initial judgment. I will indicate that we were here on June 25th, and there was a default judgment for non-appearance in the matter. That's really should be the heart of your motion. I'm not here to relitigate the matter. I'm here to indicate why you did not appear at that date and time. So you may proceed, Ms. Clark. And you'll have to unmute.
Yeah. 8 o'clock was just I didn't know it was at 8 o'clock, to be honest. I thought it was a later time until I looked at the piece of paper and it said 8 o'clock. And I was like, dang, I missed it. But as soon as I looked at the piece of paper, I woke up and I called down to the courts and I asked them, is there anything that I can do? And they told me that I could have put in a motion, and that's exactly what I did.
All right. All right. So your indication is that that you overslept the 8 o'clock, what you're indicating is an 8 o'clock, and that's why you later knew you had service, but it was after the fact.
Correct.
Okay. Response, Mr. Joseph.
Yeah, Judge, the court was clear there needs to be good cause and meritorious defense. Even if we liberally apply good cause, I don't think that is satisfied based on the facts stated here. And then obviously we have an issue with, even if we did set it aside, we're going to end up in the same spot again. There's a hardship for certain as to why it's not paid, but there isn't a legal defense. So we end up in the same spot. The court rules are in favor of judicial efficiency. If we set it aside just to restart to end up in the same place, not only does it prejudice the landlord here, but it creates an inefficiency here. So we'd ask the court to deny the motion and allow that judgment to stand.
All right, Ms. Clark, any response to Mr. Joseph's response?
He said denied my motion when the late fee, me having to pay late fees, and also letting you guys know that my income lowering, and letting you guys know that
we're not here to relitigate the facts as to why you can't pay. We're only here to litigate why you didn't show up.
that I overslept, and I thought the court date was later than 8 o'clock. I didn't know it was 8 o'clock until I looked on the piece of paper.
All right, I'm going to deny the motion to set aside the judgment. Not only do we not start at 8 o'clock, we tend to start at 8:30, because of a hardship and because of a lack of meritorious defense, and then the no excuse for oversleeping for a court date. The motion is denied. And Mr. Joseph, you'll follow that up with an order.
You can submit an order through my file. Yes, Judge. Thank you.
All right. Do you have any questions concerning 25-02770, Mr. Joseph?
Nothing from plaintiff.
All right, Ms. Clark, do you have any questions of me concerning this file?
Okay, so when you say my motion is denied, what do that mean? Because I don't.
That means the default stands, ma'am.
So what do you mean by default? Even if I'm getting help, so basically what you guys are saying is that I have to move out regardless of the situation.
It means that your motion's denied. I don't know what it means, but the default judgment for fail to appear stands pat. So whatever effect that has, the answer to that question is yes.
So, Ms. Clark, you could talk to management to see if you're getting assistance, if they're willing to work with you. You could talk to them. That would be my recommendation. Okay.
I am getting assistance. I'm going through 311.
Okay. Talk to management and see if you can work something out outside of court. Okay.
What is management? Pinebrook?
Correct.
Oh, okay.
All right. Anything else for the record in 25-02770, Ms. Clark?
No, sir.
All right. You should be all set. Thank you for your appearance today. Mr. Joseph, thank you for your appearance.
Appreciate your time, Judge. Thank you.
Thank you. And Ms. Payne, you should be all set too.